Great. Excuse me. Good morning, everyone. Welcome to our webinar discussing the Supreme Court's latest employment law decision, Muldrow versus the City of St. Louis. My name is Joanna Wasik, and I'm a Deputy Legal Director at the Washington Lawyers Committee for Civil Rights. We are thrilled to host this webinar today with the Metro Washington Employment Lawyers Association, and also to be hearing from our esteemed panelists. To introduce them, Brian Wolfman is the director of the Appellate Court's Immersion Clinic at Georgetown Law, which litigates public interest appeals in circuit courts around the country, as well as the U.S. Supreme Court. Brian has extensive public interest litigation experience and has argued 7 cases before the Supreme Court, winning 6, including the case that we're discussing today, Muldrow. He's also taught doctrinal and clinic courses at both Harvard and Georgetown Law. And Brian started his career at a rural poverty law program in Arkansas. Our other panelist today is my colleague, Hannah Mullen, who is Associate Counsel at the Washington Lawyers Committee. She focuses her work on litigation that holds prison officials, police officers, and other government actors accountable for harm that they have caused. Hannah is a magna cum laude graduate of Harvard Law School, and she worked with Brian at the Georgetown Law Appellate Court's Immersion Clinic. So we're very happy to have both of you. Before I turn it over to Lauren for a minute, I just wanted to go over a few logistical items for everyone who's on the webinar today. If you could please put your questions for the panelists into the question and answer section of Zoom, which should be at the bottom of your screen. We'll be reviewing those on our end and probably holding them and answering them at the end of the webinar, but please feel free to throw those into the Q&A there. We are also enabling closed captioning during this event, and if you want to use closed captioning but aren't seeing it currently, you may have to click at the bottom of your screen to select that as an option. All right, so without further ado, turning it over to Lauren.
Thank you, Joanna. Good morning, everyone. My name is Lauren Corey. I'm the president of MWELA, and MWELA is an organization of over 350 lawyers who represent employees in employment and civil rights disputes. We're thrilled to co-sponsor this event with the Washington Lawyers Committee. We'll take any opportunity to celebrate our wins, but particularly during a time when it feels like the Supreme Court is pulling the ground out from beneath us in many circumstances, it feels extra special to see employee rights win the day in this case. So thank you, Joanna, and your team for planning this event, and Brian for all of your work. Looking forward to the discussion.
All right, so to kick us off, I'll lay out the facts of the case and a little bit of the legal background. I expect that many of the folks who have joined us today have followed this case, closely to casually, but just in case, we'll give a little bit of the factual background, a little bit of the legal landscape, and then we'll hear from Brian on a couple different aspects of the case and what the Title VII landscape might look like after Muldrow. So to start off with the background, the plaintiff in the case, Ms. Muldrow, was a sergeant with the St. Louis Police Department, and from 2008 to 2017, she worked in the intelligence division. But then she was transferred out of that division without warning. The supervisor that made the decision to transfer her out said that the job was dangerous. She was replaced by a male sergeant. There were other indicia of sexism. The supervisor who had made the transfer decisions tended to call male supervisors by their rank, and Sergeant Muldrow and another female sergeant, Ms. or Mrs. The only new additions to the intelligence division under his purview were male, so on and so forth. At the new position where Sergeant Muldrow was transferred, her pay was the same, but a lot else was different. Her schedule was worse. She had fewer weekends off. It was irregular instead of kind of a steady Monday through Friday, 9 to 5. Her responsibilities were less sensitive, less important. The position carried with it less prestige. The new position also, unlike the intelligence division position, didn't have kind of a formal association with the FBI. When she was in the intelligence division, she was eligible to work with the FBI for overtime pay. She got kind of FBI agent-like privileges, and she was allowed to wear plain clothes, as opposed to in her new position, she had to wear kind of the full street kit that, weighed significantly more. So you get the idea. Same pay, but a worse setup. And that kind of transfer decision where somebody has the same pay, but the trappings of the job end up different, before Muldrow in most circuits was analyzed under something called the adverse employment action doctrine. So as I'm sure we all know, Title VII makes it unlawful for an employer to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of various characteristics, including sex. But in the adverse employment action doctrine, different circuit courts around the country basically invented a limit on Title VII's protections that didn't show up in that text. So even though the doctrine differed a little bit circuit by circuit, it generally required plaintiffs to show that a discriminatory change in the terms, conditions, or privileges of employment caused a materially significant disadvantage or similar, the wording could differ a little bit, in order to be actionable. So under that doctrine, if an employee was subjected to a transfer, but kept the same pay, it may not be actionable. So there are all kinds of horrible examples that Justice Kagan's majority opinion lays out. Of course, also in the briefing. One, I think, particularly egregious example was in a Fifth Circuit case. Black employees worked outside in the blazing hot Texas sun, and white employees worked at desks in an air-conditioned office. But because they were paid the same, the Fifth Circuit held that there was no significant change in their terms, conditions, or privileges of employment, so that was held not to be actionable. So the doctrine, in effect, could be pretty extreme in keeping out of court cases on behalf of employees who, from the text of Title VII, had definitely experienced a change in their terms, conditions, or privileges of employment, even when there was a plausible allegation that that change was because of their race, sex, or so forth. And that doctrine was applied here. Below, the Eighth Circuit held that Sergeant Muldrow's transfer wasn't actionable because there was no materially significant disadvantage. And the majority of the Supreme Court, actually unanimous 9-0, the Supreme Court reversed the Eighth Circuit 9-0, and overturned the materially significant disadvantage rule. Justice Kagan for the court, I think the kind of key sentence of the holding is to make out a Title VII discrimination claim, a transferee must show some harm respecting an identifiable term or condition of employment, but that harm does not need to be materially significant. So I think to kick it off, Brian, I'd love to hear you talk a little bit about what you think some harm means. We'll get into the separate opinions, but there was some criticism of the some harm rule as being squishy, and it's a little bit unclear how different it is from the materially significant harm rule that it purported to overturn. So what do you make of that? And you're on mute, my friend. Still on mute.
All right, here we go. Sorry about that. So thanks, Hannah. That was a terrific description of the opinion. So, I think you're absolutely right that the some harm standard is the standard now. I think what it means, in my judgment, and advocates out there may be forced to, tussle with this a little bit, but I think what it means in context of the opinion, and if you just pull out the dictionary, is any harm. Some doesn't always mean any, but I think in this context, it means any harm. Because, if you ask somebody, for instance, I made some money running errands, That could be a dime, or that could be $1, or that could be $10. But a dime is still some money running errands. And now let's look at the context of the opinion, which I think really underscores the truth of what I just said, which is that, first of all, the court is rejecting standards such as materially serious, material changes, material significant, significant change, material adversity. All of these are rejected in the opinion. You see this in footnote 1 and elsewhere in the opinion. So this is something, I think, just above de minimis. That must be what is going on. Now, let's turn a little bit more to the opinion. Justice Kagan distinguishes between significant harms and gets rid of that standard and says, what I'm saying is not so significant. I'm quoting now, not so significant harms are actionable. That suggests strongly that it's something just above de minimis. And perhaps most importantly, the court then says there is nothing in the text of the statute to otherwise establish an elevated threshold of harm. That is, there is no elevation in the threshold of harm. I think, again, that means just above de minimis. So let me just finish my answer. I'm sorry for running on here. But I think then we want to make sure we understand what de minimis means. And the court said just last term in Groff versus DeJoy, the religious discrimination case, something de minimis is something so very small or trifling that they're not even worth noticing. So let me wrap this up. If you look at all the adverse employment action cases, they're about transfers, they're about denials of training, they're about shift changes, they're about things like in the Peterson case, being outdoors as opposed to indoors. No one would view any of the types of issues that are actually litigated in the real world as trifling if they are accompanied by discrimination. So I think it's a very favorable opinion, but I think as advocates, we are going to have to work through these arguments.
What do you think? I'm interested in hearing what you make of Justice Kavanaugh's concurrence. So for the audience's benefit, Justice Kavanaugh wrote a really interesting concurrence that I think on the page is the most worker-friendly piece of writing of the various separate opinions. So Justice Kavanaugh's argument is there's no harm requirement, some harm, not a lot of harm, de minimis harm, whatever. There's no harm requirement attached to the terms, conditions, privileges part of the Title VII language. Rather, the discrimination that the employee suffers is the harm. That's the Article III injury. He doesn't use Article III language, but this is kind of how I make sense of it. In my head, the discrimination is the injury, and then the only question about terms, conditions, or privileges of employment is whether it's affected those aspects of the employee's employment. I'm interested in hearing what you make of that.
Well, look, I think his opinion is right. And if you look at our briefs in the case, that's our argument. And I think if you look at the text of the statute, the words discriminate against, which are the words that are being interpreted in this opinion, I think, are that's where any requirement of injury is coming from. The terms, conditions, and privileges are just descriptive of what's occurred to the employee. So I think Justice Kavanaugh as a textual matter is right. But I think what's very important here, and this ties in with my first answer to you, Hannah, is that page 3 of the slip opinion of Justice Kavanaugh's concurring opinion, where he says essentially, look, I'm right as a matter of text, but practically my opinion is going to lead to the same results as the majority opinion, and that is right. And I think this is the key language. He says here, look, it's going to be really easy to show some harm. additional harm over and above the discriminatory harm, because he talks about you can show harm by showing whether there are changes in money, time, satisfaction, schedule, convenience, commuting costs, prestige, status, career prospects, interest level, perks, professional relationships, networking opportunities, effects on family obligations, or the like. So, maybe this is a surprise to people, but what Justice Kavanaugh is doing in there is saying, I understand how changes forced by the employer, or changes withheld by the employer, or benefits provided, right? Privileges of employment, that's in the statute, privileges given or withheld, actually impact real people in the workplace. I mean, he's being the realist here, and he's saying all of those things, of course, from the employee's perspective, cause harm. And what he says is either that in 99 out of 100 or 100 out of 100 cases, this is at the very last sentence of his opinion, my view of the statute leads to the same result as Justice Kagan's view of the statute. So I know you're going to get later to Hannah, how can we deal with the opinion practically? But let me preview it for a second. One way to think about this case is when you're alleging harm and when you're proving up harm at summary judgment, look at Justice Kavanaugh's checklist.
I have one more question about kind of the majority's opinion and the rules before we get to the nitty-gritty of what we think employment litigation is going to look like post Muldrow. There'd been a little bit of chatter in kind of the essayist sphere, wondering if maybe the Justice Kagan's opinion for the court didn't adopt Justice Kavanaugh's reading of Title VII because there was concern that corporate diversity, equity, and inclusion initiatives might be at risk, either as a result of the case generally, or they would be more at risk under Justice Kavanaugh's proposed rule than under the majority's rule. I know that you and Maddie Meth, who worked on these cases with you, and who's now a clinical professor at BU, have thoughts on that, and I wanted to give you the opportunity to weigh in.
First of all, let me do another shout out to Maddie. Her work on these cases was just dazzling. So, the DEI point. So, you're indicating, Hannah, that we were aware of this. We read the press. We're understanding. We understood that this was a concern. So I have a few points to make on this. First, many inclusivity efforts at businesses can be done without focusing on protective characteristics under the statute, such as focusing on first-generation lawyers or employees and applicants from economically disadvantaged backgrounds. That's the first point. The second is that there are going to be some DEI efforts that truly don't impact terms, conditions, and privileges because they're just permissive things in the workplace. Like, for instance, allowing employees to create affinity groups on a non-discriminatory basis is just simply not a term or condition of employment. Third, and I think this is an important point, I think, Hannah, to the extent that, for instance, race-based or sex-based DEI efforts are someday deemed unlawful, in whole or in part, will have nothing to do with Muldrow, in my view. It had nothing to do going in, it had nothing to do going out, and everything to do with cases that bear more directly on those kinds of programs, such as the SFFA case, the Harvard affirmative action decision, and perhaps even already baked in views on DEI or affirmative action more generally. It just seems to be Muldrow's, I view Muldrow as important, but I think as the DEI, I view it as somewhat as a sideshow. And then finally, let's assume, in my view, counterfactually, that Muldrow could be used inappropriately and inaptly to undermine DEI. What's the solution to that? Surely it can't be that people like Jitanya Muldrow, who maintains that she lost a prestigious job for discriminatory reasons, was just supposed to grin and bear it. It's not just her case either. 14 members of the en banc Fifth Circuit last year in our Hamilton case said that a heightened harm requirement has for decades, and I'm quoting now, I think I'm quoting or paraphrasing pretty closely, thwarted legitimate claims of workplace bias. So, DEI may be a very serious concern, but you can't, you can't undermine what we were seeking in Muldrow for that reason. Muldrow buries, the adverse employment action doctrine, and hopefully, with it some, an important barrier to workplace equality.
Well, that's a perfect transition to my next question, which is looking at the landscape of employment litigation in Title VII after this case, how different in your view is the landscape going to be? How big of a deal is Muldrow?
Well, let me, I think in a lot of ways that's for maybe lots of people to discuss, but I'll give you my views. Look, I think it's a big deal because, and it's a funny thing for me to say, having litigated the cases, so I feel a little funny talking about
I knew it
in
would make
those
you
terms.
feel funny, and that's why
Yeah.
you don't like bragging on yourself, but now if you don't, you're being non-responsive to my question.
Yeah. Okay. Well, here's the thing. We, having done, many of these cases in the courts of appeals and working on these cases for 3 years, we basically read every case in this area, every single case. I'm talking about this. Discriminatory training programs, discriminatory job assignments, discriminatory transfers, discriminatory negative performance reviews, on and on and on. Real things in the workplace. Circuit court after circuit court after circuit court was holding these things non-actionable unless you could show something material. And as Justice Thomas's concurrence shows, he didn't think what was going on here was material. So and look what happened to Jitanya Muldrow. So so that's all over now. That's totally changed. And what one employment lawyer from Mississippi told me a couple days ago, when folks came into his office and the claim of discrimination was a serious one, that he viewed the claim of discriminatory intent quite serious and one that he would take on. If the case didn't involve unequal pay, a refusal to hire, a firing, a demotion, or something akin to that, he couldn't take on that case because it was going to be enormously hard to get over the adverse employment action hurdle. Now, the kind of things, again, that Justice Kavanaugh was talking about in his opinion, those are actionable if they're motivated by discrimination. And the kinds of things that Justice Kagan is talking about, where she gives the examples of cases in which people were wronged if they were discriminated against that were not actionable. She has a page in her opinion where she does that. All those cases are actionable now.
And, I think we have a lot of people joining us who litigate employment cases around the DC metro area. So that's DC Circuit and Fourth Circuit. The big deal circuit split came about when you won the DC Circuit en banc case in Chambers. If it makes sense, I'd love to kind of hear you talk a little bit about Chambers, and then if you think that the majority's some harm rule changes the en banc DC Circuit's Chambers standard at all.
Okay, so the Chambers case involved a transfer. So in that case, as you point out, Hannah, the case created the circuit split in a sense, or at least deepened a circuit split in a significant way. And it held that the transfer itself, if based in discrimination, was all that was necessary to trigger liability under the statute. And so in a sense, what the DC Circuit had held, 7-4, was that the Justice Kavanaugh view of the world was the correct one. So to the extent that there is any daylight between the DC Circuit and the opinion of the court from Justice Kagan, it's the slight differentiation between the Kavanaugh opinion and the majority opinion, which I've already explained on the ground, is going to make, I think, very little difference, particularly if litigated well. It's not like everybody on this call knows that the defendants are not going to, start, raising their hands in retreat in Title VII cases. That's not how life works. But I've already discussed, and I think we'll discuss more, how we might go forward litigating these cases. So that's the DC Circuit. You mentioned the Fourth Circuit, and because that's our geographic area here too. And the Fourth Circuit case law has just been completely thrown out by the Muldrow opinion, because one of the cases mentioned by Justice Kagan is one of our cases, Wanza Cole's case, in which we sought to go to the Supreme Court and cert was denied. She was transferred from a job as a principal to a job in the central superintendent's office. And she thought that was very significant because she wanted to be a school principal. And she viewed this as having happened because of her race. And the Fourth Circuit said, oh no, we reject this claim, not because it's non-discriminatory, but because we perceive no significant detrimental effect because she's being paid the same. This goes back to what I was saying in response to your last question, Hannah. As a practical matter, not the words on the page, but as a practical matter, significant detrimental effect, material adversity, objective tangible harm. These are the standards from the various circuits. They really meant you had to show that you were harmed in some pocketbook fashion or some way that was monetizable. And that's just out the window now. So the Fourth Circuit standard is just, done.
And so now that we're looking forward into this brave new Muldrow world, are there kind of tips or things you've been thinking about for plaintiff side employment lawyers when they're building their case? Are there specific things that maybe have changed when we're thinking about pleading or the motion to dismiss stage or discovery or the motion for summary judgment stage? Obviously, a lot has changed under this new legal rule, but are there things that jump out at you?
Yes. So first of all, this is obvious, and I'm going to say it anyway. You've got to plead harm. And I think, look, we live in the twig ball world. You can't just say I had some harm, although I don't think it would be bad at all for all complaints to say you've suffered, quote, some harm, end quote. But then I think you need more, or you certainly ideally want more in your complaint. And of course, then you have to, prove at an evidentiary level, at least to the point where there's a disputed fact at summary judgment, quote, some harm, end quote. Now, how does one do that? Everybody knows it's harder to do that, and you won't be as detailed and as reticulated at the pleading stage as you will be at the summary judgment stage. But putting aside the difference momentarily between, pleading and summary judgment, you want to be able to say everything, both from a subjective and objective standpoint, that your client or any employee or any comparator employee would not like or would have wanted from what was imposed on her and what was withheld from her. Ask your client and other employees about the conditions of the workplace that were relevant to the discrimination. Take discovery from the defendant on job tasks, assignments, job descriptions, etc. Think hard about what's meaningful about a position, and if it's a transfer case, the two different positions. If the case is about a privilege of employment, think hard about, what was the privilege that was given or withheld from this employee as opposed to that employee. There are cases, for instance, in the pre-Muldrow world where a disabled individual, and again, we're assuming the discrimination. So we're assuming discrimination on the basis of disability in that case. Some people got the privilege of parking near the employment, and other people had to park further away. Is that important? Is that some harm? In my view, of course it's some harm. Finally, I think, look at Justice Kavanaugh's list on page 3 of his concurrence. Again, I read it to you before, and see if you can make out any and all of those harms. Make out any and make out all if you can, because this is, I think, where the action is going to be. But, don't forget that at bottom, all you need is some. And I explained already why I think that is just above de minimis. My bottom line is that if you could sue over something sort of at common law, if at common law, this would be harm under tort law, or if it was withheld from you as promised in a contract, then surely it is harm for the purposes of Title VII, because as Justice Kavanaugh is saying, the discrimination itself is a very serious harm. Let me just say one final thing on the Kavanaugh point. Maybe it's sort of trite to cite Brown versus Board of Education, and of course Brown was about a very important thing, public education. But in Brown, the court holds constant the idea that anyone was harmed tangibly, because there's an assumption that the school for Black children was the same as the school for white children. Perhaps a ridiculous assumption, but it's an assumption in the opinion. And what the court is holding as Brown is that the discrimination itself is the harm. That's where Kavanaugh is in this opinion. That's not exactly where Kagan is in this opinion, but my point is, if you are making out the some harm argument and go through the laundry list that Justice Kavanaugh gives on page 3 of his concurrence, that doesn't mean you should forget about the discrimination. Mix the discrimination in as a part of the harm.
Great advice. Well, because I think we have a little bit of time before we get to the Q&A session, the last kind of big topic that I wanted to talk about is how Muldrow came to be. Because as Lauren mentioned at the top, this is not necessarily the most fertile time for plaintiff side lawyers to be seeding new legal arguments and expanding the protections for workers or for other plaintiff side folks. I mostly litigate on behalf of people who've been harmed in prison or by police, and we certainly aren't looking out at the landscape and dreaming of all the new great rules of law that we could make. So I think it's really significant, both Muldrow itself and how Muldrow kind of worked its way into being at the Supreme Court. So I'd love to hear a little bit of the backstory.
Okay, that's a fun question, Hannah. I'll enjoy answering that one. So, I was a poverty lawyer that was mentioned at the top of this, and then I worked for many years at Public Citizen. I wasn't principally a civil rights or even particularly an employment lawyer. But then I started running a civil rights clinic here at Georgetown in 2009. and we were doing some federal sector Title VII cases against the federal government. And in 2010 or 2011, I ran into this doctrine. It was in the DC Circuit. Their particular way of describing the adverse employment action doctrine was objective tangible harm. And I was flabbergasted in a case of mine to learn that most discriminatory denials of job training were not actionable, unless you could show, some additional objective tangible harm. So the idea was, we train our, Catholic employees, but not our Muslim employees. I mean, and I was thinking, wait, that can't be right. And yet it was. And the courts were never putting it that way. They were never saying, oh, well, even if this is discriminatory, it's not actionable. They were just relying on this doctrine as if it had dropped down from the sky, almost as if the words adverse employment action were in the statute. I started talking to people about it, and it was almost like this was a given. So then, years later, we did an amicus brief in the case you described earlier, the Peterson case, where Black workers worked outside in the stifling heat while white employees worked inside in air-conditioned comfort. But they didn't have a claim because the folks were doing supposedly the same job and being paid the same. And we said, no, that can't be right. So we did an amicus brief in that case. And then we made a conscious decision. Look, we think in a textualist world, we'd have a decent chance of winning this if we go to the Supreme Court or get dragged up there. Not definite, but it's a case we think we could win. So we thought about it strategically. Where do we start? What types of harms? So we started with shift changes. We had a case called Threat in the Sixth Circuit, where Judge Sutton, a fairly conservative judge, but a textualist, sided with us. We had two cases in the en banc DC Circuit, one which led to the en banc ruling in Chambers. We had a cert petition in that case I mentioned earlier about the superintendent. It's unsuccessful. Out of the Fourth Circuit, a transfer case. Then we had a case in the Fifth Circuit, several cases in the Fifth Circuit. One about transfers, one about training, one about job tasks, one of which we got to the en banc Fifth Circuit, viewed as the most conservative circuit in the country right now. But again, because it appealed to textualists, we won that with 14 votes in the Fifth Circuit, and now we're feeling pretty good about it. And then, nevertheless, we see these cases out of the Eighth Circuit, one called Nays, which is still pending, sitting behind Muldrow, and Muldrow itself. And we decided, okay, now we think we're ready to go. We've got a bunch of different examples, different contexts, so we can take, a broad view of this if need be, but limit it to transfers if need be. We have sort of what we thought as a broad circuit split with respect to job conditions generally, but also with respect to transfers. We had a spot-on square circuit split. So it's time to go. And we did. We got the support of the Biden administration. So 11 cases in 3 or so years, including 2 en bancs and a Supreme Court case. So it was sort of a long-term thought-out strategy. It wasn't, happenstantial, but it was based on this understanding that we had statutory text on our side. And this is important, that the reasons given for some heightened harm requirement were either non-existent, like people, again, that had been dropped from the sky, or lost to history, or being made up as we went along. So like one court would say, oh, it's because of this Supreme Court case. And then another court would say, oh, it's because of this Supreme Court case. And that also gave us some optimism, having the text on our side, and then really a bunch of, sort of nothing or, variegated nonsense on the other side. And so that gave us some hope that we could go forward.
Always a good day when you're litigating against nonsense. So
Yeah.
I think now I'm going to toss it to Joanna, who is going to MC the question and answer. I think we have 5 questions in the chat, some of which we may have gotten to organically, in the course of our conversation and some that we might not have. So Joanna's been keeping an eye on questions as they're coming in, so she's in charge now.
Yeah, fantastic. We do have some questions, and if anyone else on the webinar thinks of anything, feel free to put them in the chat, and we'll shoot them over to Brian. So our first question asks, Brian, when it comes to proving less concrete harms like a reduction in prestige or something kind of in that vein, what would qualify in your view as competent evidence that shows that particular type of harm? And the person who asked this question is thinking in particular about the portion of Justice Thomas's concurrence that even if you read it as charitably as possible, seems to question whether an employee's own testimony about that difference in prestige could even be competent evidence.
Yeah, look, I let me just say, I think that Justice Thomas, although he concurred, and let me just say about his opinion first, that in a sense, it's very useful because he says that the standard is just more than trifling. So he's essentially agreeing, but his application of it, frankly, is dead wrong. His application of the standard is dead wrong. I mean, look what happened to Jitanya Muldrow. And he's also wrong, and this is true in every circuit. You can prove a Title VII case or any case through your own testimony, and that's and then that goes to the jury if there's a disagreement about it. So I think that's dead wrong. So let me just turn to this prestige factor. This is important. Justice Thomas seems to think that having a high-profile job where you report directly to the chief of police and are taking on the most important high-profile investigations in the city of St. Louis involving gangs and drugs is equivalent to running a district office in a neighborhood in St. Louis. And I would ask any judge what would they think if the chief judge of their district all of a sudden just put their chambers in the basement where everybody else is on the 5th floor. And what happened to Jitanya Muldrow is far worse than that. So I think it takes, you have to see this from the perspective of the individual involved. And she went about showing this difference in job, and one might call this as a loss of prestige, by just describing in detail the differences between the jobs. And, let me use an example if you want to talk about prestige. She noted that in her prior job, she would meet with individuals like the U.S. attorney, right? She would reported directly to the chief of police. She would be able to travel out of state on investigations. She would do a host of things that were quite different. Now, I think it is very important, though, and this is where the Kavanaugh checklist is so important, that this doesn't have to be this doesn't have to be seen from an objective, reasonable person standard, the some harm standard. Title VII, and I'm now quoting the Teamsters case, the Supreme Court case in Teamsters, it's not up to others to determine what is a better or worse job. If I view this job as the job I wanted, and they're forcing me into another job, and they're doing so on the basis of protective characteristic, that violates Title VII. Think of it this way. Let's say that for whatever reason, an employer had a bias, a prejudice that this kind of work is for white people and this kind of work is for Black people. It doesn't matter whether some objective person views one job better than the other. If I apply for the job and I'm outside of the category that the employer views appropriate, but they do it because of my race or religion or sex, that violates the statute. And you see that in Justice Kavanaugh checklist. He says, interest level, networking opportunities, satisfaction. This job is just more satisfying to me. how do you prove that? You prove that not only necessarily with your own evidence, but perhaps with affidavits from family members and friends and coworkers. So, are lawyers going to have to roll up their sleeves a little bit because there may be some resistance from some lower court judges? Of course, that's always the world we live in. But I think we have a roadmap here from Justice Kagan and Justice Kavanaugh.
Thank you. Thank you. Shifting gears a little bit, we had one participant ask for your thoughts on whether, and if so, how this case and the new rule articulated here could affect hostile work environment cases with respect to the severe or pervasive standard.
That's an interesting question. I think the answer is not at all, actually, and let me explain why.
Mhm.
The defendants in these cases, obviously now without success, had always argued that the adverse employment action doctrine must be right, because otherwise it would, if you eliminated it, you would create an inconsistency with the hostile work environment, non-quid pro quo standard of severe or pervasive harassment, because that requires some level of severity, some level of pervasiveness, and therefore some elevated level of harm. That's actually wrong, because the point of the severe and pervasive standard is that something that is not a term or condition of privilege at all, say touching someone on their arm or putting their arm around someone every day, is just not a term or condition or privilege of employment if it's non-quid pro quo. But the pervasiveness or severity of it can be such that it alters a term, condition, or privilege of employment. But in the so-called adverse employment action doctrine, the employer was acting directly. There was no question that it was a term, condition, or privilege of employment. So they're just separate avenues for liability under the statute. And the reason we know that the court viewed it that way is the defendant in Muldrow itself argued to the Supreme Court that the hostile work environment precedents supported its view that there should be an elevated material harm requirement. And the Justice Kagan had so little regard for that argument that she doesn't even mention it.
Thanks. And maybe building off of that a little bit and thinking about how this case may or may not impact other areas of employment law. Thinking about the harms necessary to prove a retaliation case. So if you have a retaliatory transfer as opposed to a discriminatory transfer, do you think that Muldrow has an impact on that, or would your answer sort of be the same, that that's kind of a whole separate?
It is the same, and you see this in my answer is the same, is that I don't think that has any effect. And this is the one argument that that Justice Kagan viewed as at least being worthy of knocking down. And she does this on and I apologize now, but I'm actually looking for it right now. Yes, this is on page 8 to 9 of the slip opinion, where she says, look, the reliance on Burlington Northern, which is the material harm requirement for proving up retaliation, just doesn't apply in this situation, because the words of the two statutes are different. That's 704 as opposed for retaliation as opposed to 703A1 with respect to discrimination as to terms, conditions, and privileges. So again, the answer is these are two different requirements. And so one way to think about it is that the Burlington Northern retaliation standard didn't cross over to adversely infect the arguments we were making in Muldrow about discrimination itself. But on the other hand, the Burlington Northern standard was not relaxed at all. You still have to show material harm in proving up a retaliation claim.
Makes sense. I have a question that's specific to requirements for proving discrimination here locally under the DC Human Rights Act. Let me lob it, Brian, and I don't know how much you litigate under the DC Human Rights Act, so if it's, you know, out of your wheelhouse, that is totally fine. This person asked, could you comment if you know about DC HRA requirements for proving discrimination? It seems that they have become recently more stringent. And there's talk in that space about motivating factor versus sole factor, and the test being that the conduct at issue made a difference. It strikes this person asking this question that it's relevant to Muldrow, even though it's put into an intent context.
Okay, so that,
Yeah.
yes, that's a very good question. I am not an expert, but we do have a case now pending in the DCCA, which is solely under the DC Human Rights Act. So I'm somewhat familiar with it, but probably not, don't litigate it under it as frequently as the questioner. I do have some thoughts about it. I think as the questioner and probably many people on this webinar are aware, generally speaking, the DCCA has employed the US Supreme Court's views to interpret the very similarly worded DC Human Rights Act. Now, the DC Human Rights Act is not identically worded in some respects, but as to terms, conditions, and privileges of employment, it pretty much is. So I think it's an interesting question whether we wait for the DCCA to issue an opinion saying it formally adopts Muldrow, or just go into Superior Court and assume that it does or will. But I think it is likely that someday on this question, on the adversity question, that it will adopt Muldrow. That's a prediction. There doesn't seem to be any reason not to either adopt the majority opinion or the Kavanaugh view of it. And there may be room for someone to argue that the court should adopt the Kavanaugh opinion on it. I do want to segue to the intent point, because I think it's an important one, but I don't think it's one answered by Muldrow. But I do have some thoughts on it because it's relevant in another case we're litigating now, which is that, you know, we know that under the federal statute that proof can be made in the standard way or in the motivating factor way. And and motivating factor is another method of proof under Title VII. I don't know the case law under the DC Human Rights Act, but we know that under Title VII that motivating factor, if there's proof solely under or liability solely under motivating factor, the remedies are more limited than they would be under the ordinary intent factor. However, you know, the Supreme Court's opinion in Bostock on intent indicates that standard but for causation can stem from multiple causes. So it is quite likely that if one uses the Bostock framework, whether in a Superior Court case under the DCHRA or in the district court, one can effectively get something approaching a motivating factor laxity of proof, for lack of a better term, without giving up any of the remedies available under Title VII. Does that make any sense? I'm happy to try to repeat it, but I just think Bostock and not Muldrow opens up the potential to prove intent in a broader way without limiting the remedies available to Title VII or perhaps DCHRA plaintiffs.
Yes. Okay, I'll do one last question before we wrap up. I think you and Hannah already answered this in your previous discussion, but in case you have anything you wanted to add, this questioner asked, how much of a delta do you see between the majority's some harm rule and Justice Kavanaugh's discrimination is automatically harm rule? And I hear you saying that at least Justice Kavanaugh sees very little delta there. But in case you had anything else you want to say on that.
I can repeat myself and say one other thing. One is that, and I'm happy to repeat because I think this is quite important.
Mm-hmm.
If Justice Kavanaugh clearly sees it this way, that there's very little delta, he has his checklist. He says the cases will come out the same way 99 times out of 100 or 100 times out of 100. I think it's also important to look to Justice Kagan's opinion for the court, for 6 members of the court, which is moving a very long way in that direction, if not totally to where Justice Kavanaugh is. And I think it's totally to where Justice Kavanaugh is, because she gives these examples of situations which would now, in her view, easily be actionable, that were not actionable under the adverse employment action doctrine. You see this in the middle, a whole page of her opinion. You see this by implication in footnote 1 of her opinion, and in footnote 2 of her opinion, she explicitly takes on Justice Thomas and says, who's saying, oh, this isn't any big deal. And she's saying, oh, yes, it is a big deal. All these outcomes would change. That's her footnote 2. So I think what she's essentially saying is that there's very little delta, if any, between the 2 opinions. But what one has to do to not take any chances is to make out, do the kind of harm pleadings that I talked about, and make out at least disputes of material fact at summary judgment about harm. But what you're not going to have to do is meet these heightened harm requirements. Those have been eliminated.
Yeah. There's one question that's come in that I think might be better suited for me and Lauren, which was, do you provide legal representation at federal court in DC on employment law? So on the part of the Washington Lawyers Committee for Civil Rights, I'll say, if you go to our website, you'll find information about our free workers' rights clinic. Please feel free to make an appointment, and it's a place where we can provide brief legal advice or brief services, or give you a referral to a private firm, often a member of MWELA, which Lauren is president of, if that makes sense in your case. So feel free to make a free appointment if that's what you want to do. Okay, well, with that, thank you very much, Brian and Hannah. This was fantastic. I think we are all feeling energized and eager to roll up our sleeves and really carry this victory forward, and for our clients as well. So thank you to everyone who joined. We hope this was informative and helpful to you all as well, and hope everyone has a fantastic rest of day. Thank you so much.
And I thank you. I want to thank you a lot for doing this. And you did this pretty quickly, and I want to thank Hannah for doing a beautiful job putting this together.
Well, thank you for agreeing when I told Joanna, Brian's so nice, and I'm sure he won't be able to say no. So thank you for succumbing to the peer pressure that I was pretty sure you were vulnerable to.
Bye-bye, everybody.
Bye, everyone. Bye-bye.